Good afternoon, friends. This case is relating to the pension benefits. You all know, while discussing section 60 of the Code of Civil Procedure, I have already told you and reiterated that pensionary benefits cannot be attached. Pensionary benefits, gratuity, provident fund, none of them can be attached by any bank, any person, even though the attachment order is given by the court. Normally, you will file or you will institute a suit under section 26 of the CPC. You will get the decree. After the decree, you will go for normally execution. And one of the modes of execution is attachment. You all know very well. So, while attaching the property, section 60 clearly says which types of properties can be attached and which types of properties cannot be attached. So, the pensionary benefits or pension cannot be attached. So, this is the basic thing, fundamental thing, all of you know. But still, there are typical instances where the case law has to be explained. Right? Here, the API court once again, while disposing the case of Arevarapu Indira versus Indian Overseas Bank branch of Andhra Loyola College campus. So, in this case, which was filed as a writ of mandamus, WP number 7055 by 2021, Justice U. Durga Prasad Rao of Honorable High Court of AP, he has clearly stated that the bank cannot forcibly transfer the terminal benefits like gratuity or pension to the which were, even though they were transferred to his wife. So this decision has clearly stated. So even section 60 and also please remember section 11 of the Pension Act. Pension Act is also there. So section 11 of the Pension Act also 1871 clearly states that the pensionary benefits like pension, provident fund, gratuity, all these things cannot be attached even though by bank. So, do you think that bank people do not know? They know, but they have to recover their money, is it not? They have got a responsibility, right? Here what happened is, the husband of Indira, Mr. Vijay Kumar, he worked as a lecturer in Andhra Loyola College, Vijayawada, right? At that time, he has taken a loan of 5 lakhs, maybe in the 2019 or so. He has taken a loan of 6 lakhs, I believe. 6 lakhs from the Andhra Loyola College Branch of Indian Overseas Bank. In that loan system, he has clearly given an indication that in case he fails to repay the money, so the pensionary benefits may be attached. He has written like that. He has given his consent and bank people also have agreed for the same and they have released the loan of 6 lakhs, out of which he paid only 1 lakh or so. He is due to pay 5,17,000 or so. In the meanwhile, due to COVID-19, in 2020, this man succumbed or he died. His wife, Indira, is left alone. Anyway, she filed an application for the pension and ultimately it was sanctioned in the year 2021. She got some gratuity of around 6 lakhs or so. The pension was fixed at 75,000 and of course after 7 years it will be reduced to 45,000, like that. It is fixed. Now, when the amount has to be credited to the account of Indira. Therefore, the Indian Overseas Bank people, they have advised her to open an account. Accordingly, she opened a savings bank account with that Andhra Loyola College Branch. Right. When she wanted to withdraw the money of 6 lakhs plus 75,000 pension like that, but the bank has freezed the account, her account. They said they have got a lien because your husband is due to this bank 5 lakhs so and so. So unless you pay that money, we are not going to give you anything. So this is the litigation which has come forward. Now, therefore, she has no other go except to approach the Honorable High Court of Andhra Pradesh by filing a writ petition for mandamus. See, remember what happened is, so this woman has opened an account and she has to get the pension benefits. But what happened? Her husband has already given in writing that his pension benefits may be taken in case he fails. You all know that the bank, they have got lien. But still, and the matter has come to the High Court. So, Honorable Justice Durga Prasad Rao, placing reliance on Section 60 of the CPC and also Section 11 of the Pension Act 1871, clearly stated that even though the pension is transferred to his wife, here the important point is this one, even though the pension is transferred to his wife, so it has got the same life. That means that pension, even though transferred to his wife, it cannot be attached. It will have the same stand. Please remember. So please remember, the High Court has stated that pension, gratuity, stipend, this is provident fund. So even after changing hands, that means transferring, they retain their original character. Original character is that the pension should not be attached. Same thing, yes, very clearly stated. So therefore, the writ petition is allowed and the banks are not authorized to collect the money. Only thing is they have to go and file a civil suit. Civil suit, of course, since he died, this woman, she will be she is the legal heir. They have to go to the civil court and get back the money. That's all. But here, to conclude, I want to tell you, in this case, two important points are there. Number one, Section 60 says the property or the provident fund, gratuity or the pension, they are the personal properties to the person. Therefore, they cannot be attached. Second point, even though he dies and his wife becomes, and the pension is transferred to his wife, then the nature does not change. Pension is a pension. Even though it is transferred to his wife, it cannot be attached. These 2 points are important. Please know these 2 points and enrich your legal knowledge. Thank you very much.